Good evening, everybody. My name is Doug Stevens, along with Colleen Koch. We are the co-chairs of the Boulder Bar Civil Litigation section. This evening, we're very pleased to have our end-of-the-year CLE called Trial Practice and Jury Instruction Pointers for the Civil Litigators. We've been lucky enough to, our presentation will be led by Judges Butler and Langer on the screen, and then Judge Hartman, who's here in person. Needless to say, we're all thrilled to be able to do this in person. As the name indicates, they will be speaking on all facets of the jury trial process, including preparation, jury selection, opening statements, evidence presentation and objections, closing argument, and jury instructions. And they'll offer their unique insights about what juries and judges do and don't like, and potential pointers and pitfalls for all practitioners. So it should be a really helpful presentation for people that practice in Boulder District Court. District Court. Bruce?
No, I can't either.
Judge Langer is a former long-term prosecutor with the Boulder County District Attorney's Office. He was appointed to the bench in 2013 and went to CU for undergrad and for law school, and was a reporter with the Boulder Daily Camera before attending law school. Judge Butler was appointed in 2011, and he was a magistrate in the 18th Judicial District, where he worked since 2009, and was a partner at Lamb and Butler, where he practiced civil and criminal litigation. He earned his bachelor's degree from Keene State College and JD from Gonzaga. And then Judge Hartman was appointed to the bench in 2013 as well. And prior to government service, he practiced commercial law for more than 20 years, representing leading high-tech and consumer-oriented companies. And he worked for 10 years at Cooley LLP, chairing the Colorado litigation practice, and was a partner at the Chicago law firm now known as Reed Smith. And he was acting general counsel for Keen Footwear and Chrome Bags. And he went to the University of Michigan and is Go Blue.
Go Blue.
And his law degree from Georgetown. So we're very happy to have all three judges here. They'll have a presentation which will offer 2 general CLE credits, and then we'll have hopefully a happy hour, cocktails or food here to follow. All right, thanks a lot.
Thanks. All right, thank you, Doug. Judge Butler and Langer, you missed a glowing introduction. And for those folks, the audio only worked when we're really close, when I'm really close to the microphone. Judge Butler is going to be emceeing this. We'll have questions afterwards. I think we'll have time. Appreciate everyone coming in person. It's very exciting. So Judge Butler, let me turn it over to you.
Thank you. And I do want to thank everybody for showing up, whether it's because you needed those last end of the year credits or you're really interested in the subject matter. We really appreciate it. And although I can't see you, if it's like most of the CLEs that I've presented at, we usually get the folks that don't need to be here usually show up the most, and the folks that most need to be here don't show up. But I do appreciate it, and I apologize that I could not appear in person. I have a 6 o'clock Zoom meeting that I have to attend, and I just couldn't arrange both. But I thank you for allowing us to do this. Trial tactics and jury instructions, and it really is what both judges and juries like and dislike. And for many of you who may have tried a bunch of cases over the years, you get a general sense of it. But I was just adding up, and between the 3 of us, I think we have about 30 years on the bench, and we've seen a lot of trials. So we might be able to give you a little bit more insight than the cases just that you try, because we talk to every jury panel that comes along. And we have our own sort of likes and dislikes, of course, and as judges, we share those among each other as well. And I think that's important for you folks to know as well. So with starting the presentation, and hopefully you can see the PowerPoint well enough, before you even get into court, every lawyer should know these things. And these PowerPoint things are really just sort of topical. And then I'll have Judge Hartman and Judge Langer make further comments, but I'm going to kind of go through those. If you didn't already know it, judges can and do talk with each other. And I always talk about credibility because that's so important. And if you are somebody who is known as having great credibility, if you know your rules of evidence and you present a good case, every one of us is likely to know that. And of course, the opposite is also true. You know, if you're somebody who shows up late, you file useless motions, you're unprepared, you don't know your rules, you don't put on a good case on a consistent basis, we'll all likely know that too. And in case you wonder, we often know judges from other districts as well. And I know on occasion, not that many times, but I'd say a handful or maybe two handfuls over the time I've been on the bench, if I have an attorney appearing for a trial or something that's of some substance from another jurisdiction, and I don't know that attorney, but I know some judges in that jurisdiction, I might reach out to them and ask what they know about the particular attorney. And I've had judges from other jurisdictions do the same for me. And so it really is important that, you know, you not only establish good credibility, but you maintain it throughout. And then I have that last line, which I've always believed, which is it can take you an entire career to build good credibility, but you can lose it in one instance. So, you know, remember to obviously be honest to all, and that's everyone, the court, parties, opposing counsel, even if it's to yours or your client's detriment. That candor to the tribunal is not only really important, but it can make or break sort of what you're doing in front of a court, both with the jury as well as with judges. So, Judge Hartman, what do you want to add to that?
Well, you really summed it up, and of course, thank you for everyone for being here. You're the ones who probably don't need to be here, but hopefully we can pass the word. When I first got on the bench, Appellate Judge Carparelli, who I worked with John Baker and Rich Gabriel on some ethics issues, gave me some great advice. He said, don't lawyer for the lawyers. And I've tried to do that. You're all probably better lawyers than I ever was. But we have a unique perspective, not being involved in the case and having seen so many lawyers and so many jury trials, that hopefully you'll find this somewhat helpful. I think your reputation is probably your best asset, just like the credibility. And when you come to our courtroom, your reputation will precede you, but you can make it either better or worse. So please be respectful. You don't have to be overly formal in Boulder, as many of you know, but be respectful to the court, to counsel, and to, most of all, the jury members and the jury pool. I think one of the things that probably irks judges more than anything, hey John, is wasting the jury's time. We're getting paid by the state or underpaid by the state, but those folks are here for peanuts or nothing. So that's would be my overall takeaways. Be efficient, be respectful, be collegial. All of you here have those traits, but you can spread the word. Judge Langer?
Yeah, the only thing I was going to add, you know, I know from my time trying cases that, you know, trial lawyers keep book on the judges, and that's fine, but, you know, it kind of works both ways. And, you know, we do have opinions and we share opinions amongst ourselves, and your reputation is really critical. You know, when there are things where we can give you some leeway or not, or where we can be skeptical of an explanation or not, you know, it really helps if you have a reputation for honesty and candor. And so I just want to, you know, sort of second what Judge Butler was saying, that, you know, a reputation is just so valuable and it's so fragile. It doesn't take much to damage it. So it's just something to think about.
And just on a side note, you know, of the one of the three of us that's in person, of course, we had to send the best looking and the best dressed one. So that's for Judge Hartman.
feel like Daniel. I feel like Daniel in the lion's den though with this group.
So some of this has already been summed up on the next slide, but these are just sort of really succinct pointers that if you keep in mind, you're much more likely to have success. And success isn't always winning the motion or winning the case. It really is just the ability to put on the case and have that established reputation, credibility, you know, always be prepared. It still drives me a little bit goofy that I'll have lawyers show up for a hearing or a trial and they don't have use of the technology. They don't have enough copies of their exhibits. They don't have just things that you would think would be pretty simple. Be succinct, as Judge Hartman was talking about. Juries hate having their time perceived to be wasted. Whether you're really wasting it or not, that remains to be seen, but be succinct. And by that, not only does that mean make a shorter presentation, but actively confer all the time with opposing counsel about, hey, can we agree to the foundation for this? Can we agree to this particular fact? And sometimes you'll reach an attorney who won't agree to anything. I get that. But a lot of times you can. And I can tell you from talking to many juries over the years, they love it when a case gets put on in what seems to be an efficient manner. And they really don't like it if they feel like they've just wasted their time, whether it's in the courtroom or sitting in the jury room. Obviously, be professional at all times. Some of that's little stuff, some of it's the big stuff. Being professional to all is really important. And that includes everybody. I think Judge Hartman mentioned the jury, the opposing counsel, the court, but also to every witness, to the court clerks, to anybody you come across. If you act professional, it really helps all the time, even when the other side's sort of wallowing in the mud. Be on time. That's sort of a given that should happen. You know, I always think when I practiced, I thought if I was there 15 minutes early, I was on time. If I showed up at the time of the hearing, I was late, was sort of my theory on it. And be polite, of course, is going along with being professional with everyone. Judge Hartman?
I'll just focus on one thing because Judge Butler summed it up pretty well. Technology, come to our courtrooms. The Justice Center is a little quirky. Each courtroom is a little quirky. Call our clerk, come by, test the audio-visual before your trial, before your hearing. If you have an Apple computer, you'll have to have a special adapter, all these basic things. You don't want to come to the hearing, and all of us have had this happen, I'm sure some of you have had as well, where the lawyer just can't get the tech to work. And that's a self-inflicted wound. So come contact our CJAs, arrange a time in advance. We'd be more than happy to accommodate. The technology has improved, but it's still probably the best that 1980 has to offer.
I should add one thing, though. Every courtroom does not have the same technology, and so that's really important too. So just because you tried a case in front of me at one time, another judge might have different technology. So always feel free to try it out ahead of time. Judge Langer?
You know, the only thing I would add, I think Judge Butler mentioned earlier that we debrief with the jurors after every jury trial to the extent that they want to. And one of the things that we hear, you know, we do get feedback about the performance of the attorneys. And one of the things that I hear a lot is when an attorney is clearly making it personal. You know, I think that the best trial lawyers don't let that happen. I know it can be hard if opposing counsel is, you know, knows where to poke you, but juries pick up on that, and they don't think too highly of lawyers who make it into a personal battle. And so you're really hurting your client if you let that happen.
And they see they see everything, especially criminal juries, but even small 6-person juries see everything. They see interactions between you and co-counsel, between you and your client. They are smart and they talk, especially in civil trials where they can pre-deliberate. So be careful. sorry, Judge Butler.
I was going to mention that we've talked among ourselves at times where you've had a trial and an attorney gets a favorable result, not because of them, sort of in spite of them, but would the result have been even better if they had been acting in a professional manner? And you have to wonder about that, because as good or as bad as an attorney may be, my experience is juries always try to do the right thing for the case and try to do it based on the parties. But an attorney really can really help or really hurt their client's case. So you should always keep that in mind. And Judge Langer's right, they see everything. They notice what somebody's wearing, whether they're rolling their eyes, whether they're paying attention. I think I've had some juror write a question about a lawyer who seemed to be typing on their cell phone during a hearing. So they look at things and see things. So I think those were great comments. Let's talk a little bit about jury selection. You know, you should already understand the voir dire process, but if you don't be shy about asking. You know, if you haven't tried a case in front of a particular judge or just haven't tried as many cases, never be shy. And usually in the trial management conference that I have for jury trial cases, I'm happy to tell the attorneys, here's how I do it, here's why I do it this way, here's what I expect, but feel free to ask the questions. And I talk about trying to engage everybody and talk to the entire panel, because I've had it where you have, 15 or so people in the box and you're getting down to a 6 or 7 person jury, whatever the number might be if you have an alternate. And, ahead of times the lawyers know you got this much time and you spend most of it on, half the jury panel. A couple of them you never talk to and think, man, that's kind of dangerous. So I suggest you talk to everybody at least a little bit. And then for creating a good record, as you folks probably know, in June of 2020, the 20th Judicial District, because of the pandemic, terminated all their court reporters. So most of our trials now are on the recording device. So if you're talking to a jury member, please make sure you just say their name. Ms. Smith, did you want to follow up? Or Mr. Jones, what's your thought on that? And that really helps us make a good record, which is, I think, the judge's job for sure, but it also goes to counsel as well. Judge Hartman?
All good points, of course. Just ask questions about the particular judge's process. Civil trials, the voir dire is usually not quite as touchy as some criminal trials. But judges will have a certain plan for jury selection. You should make sure you know it. If the judge doesn't have a pretrial conference, which I think all three of us do, ask for one. Ask questions if you're unclear. What you probably want to avoid is objections during voir dire. The jury doesn't like it. It kind of breaks things up. Judges don't like it. So avoid those obvious improper questions, the staking questions, the golden rule questions. Avoid specific reference to evidence because you're going to get an objection and the judge will have to rule on that and admonish you. But I guess my point is understand the process of your particular judge, and if you're unsure, just ask questions.
Judge Hartman, what would you...
Yeah, I don't have much to add. I was just going to say that anything that you want to clarify, anything that you're not sure about, we all do trial management conferences, and we're happy to discuss in as great a detail as you'd like how voir dire is going to be conducted.
All right, our host had one question. I'll repeat it.
In Boulder, oftentimes you don't know who your trial judge is going to be until the week before, which would sometimes be after the trial management conference. Yeah. What would you recommend in that regard, I guess, with respect to jury selection and anything else that might be particular to your trial judge that may be unique from your colleagues?
All right, so the question was about the trailing docket where you don't always know who your trial judge is going to be. It's a great question. I think you should ask your presiding judge, and he or she will be able to give you probably some idea as to who is going to try it. or some idea that it's not going to be, say, Judge Langer because there's a criminal trial that has some precedence. If that's the situation, hopefully the judge will put some of the basics into a minute order, just time for voir dire. And if you want to come in once you get the notice of who the judge is going to be and try to schedule a conference, it's usually a tight schedule, but the judge will probably try to accommodate that. And the presiding judge for the division will probably give information to the judge who's going to try the case. I don't know if you guys want to add anything to that.
I'm sorry, are you getting another question, Judge Hartman?
No. If you wanted to add anything to my response.
The rule of thumb for scheduling is that sort of first choice is if the case is out of your division, you're more likely than not, but certainly not certain, to get the trial. But depending upon the number of other trials going that particular week, the case, of course, could be assigned to anyone. But I've had lawyers ask at the trial management conference sort of where they stand, and I'll look at that week and I'll say, okay, I still have, 3 trials set that week. This appears to be the oldest one, I don't know if we're going to have excess criminal trials, but the likelihood is it would end up with me. Or I'd say, geez, I've got a criminal trial that I know is already going to be set for me, or I've got another civil trial, so it's likely to get assigned to someone else. Contact that division as soon as you know to try out the technology, etc.
And the only thing that I was going to add, typically when I have a trial assigned to me, whether it's my own or someone else's, I start at 8:30 on the first day of trial, and the jury will come in at 9. So generally we have some time to discuss any concerns that you have, any questions that you have just on the morning of trial before we bring the jury in.
Yeah, I think
I also send an email out to counsel once I'm assigned a case that sort of sets forth my sort of rules of thumb for my courtroom. And it's the little things like, make sure you stand near a microphone, make sure only one person speaks at a time, make sure you have your witnesses lined up. But I try to give an outline in an email to counsel before every jury trial.
Thanks.
Some more stuff on jury selection is, having specific topics to chat with them about. And, if you got a rambling juror, try to figure ways to move on to someone else so that you use your time wisely. And I've had a couple of trials recently, which I thought it was a little weird, but, a juror, when I asked the hardship question, and they say, yeah, I've got a hardship, and they say what it is, and I say, okay, it doesn't meet the automatic disqualification, I'll let the lawyers follow up. And in 2 cases recently, nobody followed up. And one lady had, I think it was a funeral of her grandmother or something, and I finally called the lawyers up. And I said, anybody want to do anything about that? And I think one lawyer said, we'll just let the selection process. But I said, no, because what if she's selected? So I said, I'm going to just enter an order excusing her. But, if somebody claims a hardship, follow up. Unless there's already been a request to excuse somebody, you probably want to know, if you're on this jury, are you going to be able to pay attention? What's going on? I had a trial last April where during the trial I arranged to have 3 jurors go get their COVID shots. We just arranged schedule around it, but they were still able to serve on the panel, but they had scheduled the COVID shot. And so, if you got something unique like that, raise it and make sure everybody knows what's going on. Judge Hartman?
Yeah, I'm sorry, I was just going to jump in. Yeah, I was just going to jump in that, there's some hardship claims that are just obvious. I'm having surgery tomorrow. But there's some that are a little more borderline, and you probably know as well as we do that if we start granting them, it opens the floodgates. So we need to be a little conservative about that. So typically what I do is, the 3 or 4 or 5 people, however many it is, that have sort of a borderline hardship claim, I will tell them that we'll come back to you, and I let the attorneys talk to them, and then I have you up to the bench and sort of get your positions on each one and then make a decision. So, I think it's important that the lawyers know that they're sort of part of that process, although obviously I have to make the final decision.
Yeah, and no one wants a juror who doesn't want to serve. Some people will grudgingly serve, but it's not in your party's interest or the court's interest to have a jury or a juror that doesn't want to serve. I think that's pretty obvious. Also, Judge Langer and I were on the committee to recommence the trials after the lockdown, and the chief judge and some directives we've had from other courts have basically suggested we are more liberal with hardship excusals than we were pre-pandemic, because jurors are anxious, they're facing financial hardship, and if they haven't asked for a deferral of service, or if in advance, or if they haven't asked for a medical excuse in advance, they may be in a surprise situation when they are picked on that jury, and we're trying to avoid causing further disruption to the jury process.
Thank you. We used to have an expression in my office when I practiced law, which was, you really end up with the jury that nobody wanted, because one side's going to try to get rid of all the jurors they think are favorable to the other side, and the other side does the same. And theoretically, you end up with the jury that nobody wanted, which hopefully then is a fair and impartial jury. And that's all you're looking for, at least as a judge. That's all I'm looking for in getting a jury selected. And I think Judge Hartman's correct that, people are pretty adamant about telling you how much they don't want to be on a jury. And I think Judge Langer made the comment of, we don't want to open floodgates. And so sometimes I may think somebody has a good reason, whether it's hardship or something else, but rather than just granting it so more hands fly, I say, well, I'm going to let the attorneys inquire further about that and kind of keep that down to a minimum, because is it really a hardship, or it's, gee, I really don't want to do this. But afterwards, pretty much universally, when I ask, was this a worthwhile process, every juror says, yeah, this was a great process. I'm glad I did it. And then I say, tell your friends and tell your family, because this is really important, because when they get their summons and they say, how do I get out of this? You can say, no, I did it. It was really a pretty good process. So, that's really all we're looking for, is a fair and impartial jury to both sides. And although I know you want the jury that's going to be favorable to your side, you're really hopefully just going to get a fair and impartial jury to hear your case. So I'm going to move on now to opening statements, and maybe I'll defer and go last this time. Judge Hartman, what do you want to say about opening statements?
I think a lot of the folklore about opening statements is probably overblown when we talk to jurors. Most of them do keep an open mind throughout the case. However, it is a chance to put your best foot forward, obviously, and introduce the case. They probably have an idea about what the case is about during voir dire, but they really don't know the specifics. So as we put in the PowerPoints, tell a story. Make it interesting. And you all have probably had trials, or you've seen good lawyers, or you've taken classes where there's different philosophies, but you really have to get the jury's attention, with the caveat that you don't want to be clownish. I think the jurors, especially in our district, know that this is not going to be like a Law and Order. There's not going to be huge drama. They do want a story, but they don't want something so over the top that they'll see you as really a stereotype of a lawyer. If you're going to use technology, be facile with that technology, and make sure the technology adds to your opening statement, not detracts. A PowerPoint like this is really just an outline of the case, which is fine. It's probably neutral. But if you're going to go beyond that, make sure it works. Test it with your colleagues. Make sure the technology works with the court. Do not draw any objections. It's like with voir dire. You don't want the other lawyer to object. The other lawyer probably doesn't want to object. The judge doesn't want to necessarily rule. So avoid those overly argumentative opening statements. Avoid mentioning of evidence that may or may not be admissible or that you may not admit. You're making a promise to the jury with your opening statement. You want to keep that promise. And try to be affable. Is all I could say. Is so many stereotypes are negative about lawyers, especially certain types of lawyers. And you're the face for your client. I think you all know that. And juries really respond to a lawyer who is organized, affable, and can tell a good story.
Ms. Langer?
You know, in the PowerPoint, it includes the line, try to get the jury to want to help you. And that made me think back. I don't know who's there in the room, but if you went to CU in the 80s or 90s and you had Dennis Hines for contracts, you probably heard this because he used the same lines over and over every year. But he would say that to be a successful trial lawyer, you first want to get the jury to like you and want to find for your client, and then you had to give them something to hang their hat on. And you know, I think that actually starts with voir dire, because that's where you're really having a conversation with them, and hopefully your personality can come across. And then when you get to opening statements and you're starting to talk about the facts, you know, you just want to give them a few nuggets that they say, oh, okay, that's something that I can get my teeth into. And you know, this guy that I like, guy or gal, this is the evidence that I should maybe focus on. I agree with Judge Hartman that I think, you know, you always hear that trials are won and lost in opening statements. I think that's an exaggeration, but you really start to make an impression, and, you know, opening statements are an important part of that.
One of the things about opening statements, I think, is to give that jury a good outline, because your witnesses don't usually or always come out in the chronological order of what happened. You know, if you have a personal injury case with an automobile accident, you know, you don't always start with, you know, the accident, the police officer, this doctor, that, because of scheduling issues. And so I think it does help to tell the jury what they're going to be hearing. And as noted, tell a story. So it's not, you know, this case is about an automobile accident on June 5th, 2020. You know, maybe it's more like June 5th, 2020 was a beautiful day in Boulder, and my client, Ms. Smith, was driving north on 28th Street when all of a sudden she was struck on the passenger side by the defendant's vehicle coming through a red light. Now, very quick, but you've sort of lined up what's going on here. And I think that's really important. If you then start talking about, she treated with Dr. Wilson 16 times, he diagnosed this, tell it as a story. You know, Dr. So-and-so, you know, has determined after seeing my client many times that she has this. And, you know, if you tell it more like a story, not only is it more interesting, but I think, as noted in the PowerPoint and the other judges' comments, you kind of get that jury involved in the case. They kind of want to now do something, because it's not just sounding like this dull thing. But as also mentioned earlier, you don't want to go over the top, whether it's emotionally or with comedy or anything like that, because at this point, you really don't know if a jury likes you or not. And so that's a risk if you go over the top as early as an opening statement or any time, really. So keep it interesting by making a story. You know, think about if you were at the proverbial cocktail party, right? And somebody says, oh, you got a trial coming up. What's it about? You'd probably tell a story. You probably wouldn't tell it like a lot of folks tell opening statement and just sort of this series of statements of facts.
Judge Langer, you want to take the next one?
I'm sorry?
I'm sorry?
Do you want to take the next one, Bruce?
You know, you're breaking up. I'm having trouble hearing you.
All right. There goes the tech.
Front row.
No.
If there's more comments, feel free to make them, Judge Hartman.
No, just roll to the next slide.
You kind of fade on us. I don't know if it's the technology or what. So now we're going to move on to trial practice. And Judge Langer, why don't you lead this one?
All right. So, you know, I think that, you know, this sort of flows from be prepared. It's really important. One of the things I want to tell you just to start off is that I think that we all see our job, our number one job is to provide a fair trial for both sides. But close behind that is we feel very protective of juries. And we feel like we're there to make sure that the jury's time is not wasted, that they're not kept waiting because someone's late or someone's not prepared. So a lot of what you're seeing here kind of flows from that. It's important that you're organized, that you have witnesses ready, that you have exhibits ready. There's a reference here to Rule 43 and remote testimony. We've certainly, I think, loosened up sort of the criteria for when we're willing to admit or allow remote testimony in the time of COVID. But it's incredibly frustrating for everyone if the technology doesn't work. A lot of times it's the witness who has the problem. But as the lawyer calling the witness, you're ultimately responsible to make sure you can present that testimony in a way that a jury can hear and make sense and that there aren't delays. One of the things that we often see is that as you move through your list of witnesses, a lot of the evidence is repeated over and over. And I don't think that's particularly helpful or a good use of a jury's time. You know, it's been referenced before, but I can't think of anything, well, it's incredibly important during a trial to watch the jury. You know, we watch the jury, and I don't know how many times I've looked at a jury and wondered why a lawyer is not picking up on the body language, the facial expressions, and not reacting accordingly. So that's important. Anything you can do to stipulate to exhibits, authentication, foundation, whatever you can do to avoid using time on things that doesn't need the time spent, a jury will appreciate. And then we talked about not getting sideways with the judge. You know, I don't want to create the wrong impression. I don't think that certainly none of the three judges that are here talking to you think that we're somehow on some level above lawyers in terms of the respect we deserve. But I think it is true that when juries see us sort of trying to manage things in a way that benefits them as much as possible, they tend to like us. And if they have to decide whether they like the lawyer or the judge, so you know, just a word to the wise that, you know, even if you're not, if you don't like a ruling or you don't like the way we're handling something, you probably don't want to take that up too much in front of the jury. Not because it offends me particularly, but because it's probably not doing your client any favors.
Hartman?
Yeah, just to focus on one thing. The jury doesn't expect that the trial will be like Law and Order, but they do expect things to be efficient and to move along and to not have lots of time cooling their heels, either in the jury room or just between witnesses. So a couple tips that I've seen work really well, and I think it's often in criminal trials, but there's no reason why it couldn't be in civil trials, is have witnesses teed up. And I know many clients are on budget restraint, but have a paralegal or a junior associate or even a law clerk bring a witness from the hallway into the courtroom, have that witness ready, have the witness who's on deck ready, and just roll. And the jury will really appreciate that. Now, there will be some witnesses who are uncooperative. and you'll have to subpoena them. You'll probably subpoena them for the Monday of the trial. You have to communicate with that witness as to when his or her precise testimony will be, so that you can present your case efficiently, that you don't have an annoyed witness who may be somewhat hostile to begin with and is now totally hostile or unwilling to be there. And again, if the jury has to wait 10 minutes because someone's not here, or if you run out of witnesses at 3:30, no one's going to be happy. So really think about efficiency in running your case smoothly. And the jury and the judge will really appreciate that, and it will be in your best interests.
It seems to me that there are too many cases where the court is provided with either books of exhibits, or they're uploaded online, but many of them are the same exhibit. You know, exhibit 3 is the same as exhibit E, and things like that. And it's just unnecessary. You can save yourself time and energy if you really do have that active conferral to try to have stipulated exhibits. And as mentioned, if you can stipulate the foundation, authenticity, all those things, even better. Because I can assure you a jury is not interested in listening to a foundation of a complicated document if it's something both parties agree to. I've always also thought it was a little odd, but it happens where a lawyer will submit a proposed exhibit, the other side decides to use it, and then the lawyer who has it as the proposed exhibit objects to its admission. Why did you have it as a proposed exhibit then? So those are the kind of things you can try to work out ahead of time. And I do agree with both Judge Langer and Judge Hartman's comments. The comment about not getting sideways with the judge, it really doesn't have anything to do with us. We don't really have big egos, but the jury, as you heard, they watch everything, and they watch the interactions between the judge and the lawyers. And there have been occasions where lawyers, getting a little worked up, and they'll send the jury out, and they'll say, counsel, you can make whatever record you want when the jury's not here. I'll always allow that. But you want to be careful about how much you want to argue with me, because every afternoon I have my law clerk bring a bowl of candy into the jury room. I can guarantee you that jury likes me. I give them candy. They may or may not like you. So just be careful about that. But I'm not trying to dissuade anyone from taking issue, making a record, or even disagreeing with what the judge has done, whether it's a ruling or something. But use your demeanor, use your experience about how you're going to handle that. Objection, overruled. Judge, I'd like to make a record. Okay, on the next break, you can make a record, or something like that. Rather than, sort of starting into this argument, which, one, the judge is likely to shut down pretty quick because you might be talking about things the jury shouldn't hear. And two, now the jury sees that you're just somebody who's arguing with the judge. And as I said, and you've heard from the other judges, that doesn't necessarily reflect well on your client. So there are plenty of ways to make a good record, and that's your job too. I get it. Just try to do it in a way that doesn't impact in a negative form what you're presenting to the jury. All right, we're going to move on to more trial practice. I'm going to take this one. One of the things, actually, I want to make one quick comment back on opening statements that I meant to, because I've seen a lot of lawyers have legal pads with their openings. And even if they're not reading it, they're really using it quite a bit. My practice was to take a little index card and put down the 5 or 6 key points that I wanted to make sure I made, whether it's opening or closing. And that way I could look at it and go, geez, did I talk about this? But it was really me just telling a story to the jury. And I think that presents better than somebody who looks like they're reading or relying heavily on a lot of notes. That's a comment about opening. But now on trial practice, and this sort of segues into jury instructions, but not quite there yet, is looking at jury instructions. When you get a case, and whether you either file a complaint or an answer, affirmative defenses, counterclaims, whatever, one of the first things you should do, maybe even before filing that pleading, is look at the jury instructions for that claim or defense or counterclaim. What are the elements I need to prove? What witnesses will I need to call to prove this? What exhibits will I need? And if you start that process early and not waiting until, the trial management conference to start working on your jury instructions, not only do I think you'll have a better trial for yourself, because you already know what you have to prove your claim or your defense. And if you don't have sufficient facts of whatever, you may decide you really don't want to bring that particular claim. Again, overall, the presentation happens, right? You bring 3 claims, and 2 you might be able to prove, but 1 you have just almost no evidence on. That can hurt your credibility if the jury goes, gosh, he said he was going to prove X. I haven't heard any evidence about it. What should I wonder about these other claims? So think about that, and I think it really helps you to decide early on, what do I need to do to prove my claim or defense? What witnesses, what exhibits? By looking at those jury instructions early in the case, rather than waiting for later. Judge Langer?
I really don't have too much to add on this one. I think it just goes back to being prepared and organized.
Yep.
Judge Hartman?
Nope, same. I'll talk on the next slide.
Enough said about that one. All right. Judge Hartman, would you like to take this one?
Yeah, I guess I will. So more on trial practice, and this is not a trial practice course. All of you have either taken those or have experience with trials. But you do have to realize that juries have limited attention spans. And it's not that they don't want to do a good job. It's that sometimes they just can't. And we could pinpoint certain generations, but I think it spans every generation. If you have a case that's document intensive, you have to figure out a way to make that digestible to the jury. And you can talk with opposing counsel, you can come up with summaries. Sometimes you will have to have a document heavy case, but look at ways to break things up. Use pictures if possible, diagrams, graphs. The one thing I think juries don't understand is when you have to have a custodian of records come in, they will say, why did that person from Wells Fargo come here? If it's an important enough case and you have a good enough lawyer on the other side, he or she is going to have those documents admitted, stipulate. And the judge will thank you for it. And you can thank the other side. You thank you, Mr. Smith, for agreeing to this. And the judge will nod, and everyone will think you're getting along and not wasting the jury's time. Watch the jury. We're also intent on our research and our case. Take a look at the jury. If you have a co-counsel, have him or her observe the jury. Stipulations for tedious things, stipulations for exhibits. Especially a bench trial, we're talking about jury trials now, but bench trials, there's really no reason why almost every exhibit, except for a few outliers, shouldn't be stipulated, and the judge will give it the weight that he or she feels is important. And the last thing, when I was a junior lawyer, I had my first trial with a senior lawyer, and I would write down on little Post-it notes like objection, objection, and he would be nodding and nodding and looking at me like good. And he said, Andy, those are some really good objections. And I bet the judge would have sustained some of them. But here's what happens when you object. You object, and the judge says, response. Or the judge says, can you read back the question to the court reporter? Or can you repeat the question? And there's an objection. And even if the objection is sustained, the lawyer re-asks the question in a different way in most cases. It wakes up the jury. They have seen some drama because this is what they see on TV. And now the jury has heard the question 3 times. And absent particular rules of evidence, most of these issues in a civil trial are going to be presented to a jury in some form or fashion. So be mindful of your objections.
Yeah, I was just going to say, you know, I always like to tell at least one war story in one of these CLEs. And when I was trying cases, I was the DA, so it was all criminal cases. I had a case where we had like a kilo of cocaine in a big bag that we were showing the jury that this guy was found with. And he also had a little scale with a little bit of residue on it, and the judge had excluded that because the residue was never tested. We couldn't prove it was cocaine. But for some reason, the detective decides to talk about that there was a scale with some white residue on it, and there's an objection. And what ends up happening is the judge goes, "So you're objecting to the white residue?" "Yes, I'm objecting to the white residue." The objection is sustained. The jury is to disregard the fact that there's white residue on the scale. And now the jury is thinking of nothing more than the fact that there's white residue on the scale. So, you know, if you think that there's something that's bad enough for a mistrial, you know, you probably want to talk about it outside the presence of the jury. But making that objection, even if you're right, sometimes you're shooting yourself in the foot. And then just in general, I think sometimes juries get annoyed by lawyers who object. Even if you're right, you know, even if it's probably something, as Judge Hartman said, that if the question can be re-asked in a different way, or, you know, something, or it's not that damaging to your case and it may not be worth objecting. And so I think you need to be very, you know, conservative with your use of objections and make sure that they're obviously both right legally and that they're important enough to your case that you want to make an issue of it.
Yeah. And now one thing that Judge Carparelli said was don't lawyer for the lawyers. There'll be times when I'll try to use my telepathy, which is very ineffective, to the lawyer. And I know that these colleagues have done that too. It's like, please object. Just please object so we can get off of this topic. And if you see the judge like staring daggers at you, just think about what might be happening. I don't know if you guys do that, or your telepathy works better than mine.
I always tried not to be the jack-in-the-box lawyer, objecting. And I always felt that if you only objected when you really thought something was improper and was going to hurt you as well, then the jury also would take the objection more seriously than if you objected 100 times before then. And there are a lot of times where I actually respect the fact that a lawyer isn't just serially objecting, although I agree with Judge Hartman. There's a lot of times I'm messaging my law clerk on, why isn't he or she objecting? Oh my gosh, I can't believe they're not objecting. And you want somebody to get this issue behind.
Right, and what
also on your documents, I'm making up a number, but I'm guessing, I don't know of a jury that will read more than 40 or 50 pages of documents during deliberations. And if you give them several hundred pages, and 40 or 50 may be a lot, it might be a dozen. But if you give them a whole bunch of documents, you may want to have previously shown and highlighted certain ones and really pointed out the ones you really want them looking at. Because at least from my experience of doing trials and talking with jurors after, they're not going to read a whole ton of documents. And so it was mentioned to do summaries and things like that. That's a really good point, really good thing to do if you're able to do so. And yeah, if a jury's not paying attention and they do it lots of different ways, closing their eyes, turning their back, a lot of jurors are really poker faced. That's good. But sometimes you can tell they're not happy with whatever's going on. And if that's the case, and you don't think it's helping you, you may want to switch tactics of what you're doing. And sometimes it's as simple as, I notice a juror maybe doesn't look like they're paying as good attention as they should. I'll say, maybe we ought to stand up for a minute. Maybe we ought to take a little early break for our afternoon break, whatever. And you folks are able to do that as well, to say, you see a juror fall asleep, and whether you want to do it by saying, can we approach about something, or you say, Your Honor, is it possible to take an early break, for, our purposes? And that often will work. Closing statements. Judge Langer, you want to take this one?
Sure. I agree with what this slide starts out with saying, tell a story. This is really your chance to perform. This isn't just an opening statement, it's closing arguments, really. And so this is where you really get to perform. You never know exactly how the evidence is going to unfold, but when I was trying cases, I would always have sort of a theme in mind, maybe, some quote, or some analogy or something that helps spice things up. But you also need to weave into that the facts that you believe prove your claims or your defenses. And so a lot of lawyers, what I see them do is they'll have a PowerPoint slide of elements of a claim, or some such thing, and basically say, we need to prove this and this and this. These three are obvious because you heard this and that. This other one is really where we think you need to focus your attention, and here's the evidence that you should believe carries that claim. Objections are, I think, difficult in closing arguments. I know there's a school of thought that you object to break up the flow. I don't think anybody really appreciates that, or it's really having the effect that you think it will. And most of the objections I hear in closings are misstates the evidence. And you're almost always going to get a response from the court, which is, ladies and gentlemen, you should use your memories as to what the facts are. Go ahead, Mr. or Mrs. Attorney. It's really not going to accomplish much. So I would think carefully about objecting during closings.
Thank you. Judge Hartman?
Yeah, those are great points. What I like to use when I was practicing, Judge Butler mentioned note cards. What I found is effective, and I know this is kind of elementary, but there might be junior lawyers, is I would use a manila folder, but not have any papers in it, and just write on the manila folder, so you have two pages, and it's nice and stiff, and you don't have papers that you're fumbling with. And on that folder, like Judge Butler said, you don't have your closing or your opening. You just have your highlights, your outline in very big letters. And you use that, and you can walk around with that, and it doesn't look as silly as a legal pad that's got pages and pages of notes which you're fumbling through. So you look a little more professional. At least I thought it worked. You won't have an objection that's sustained in most cases in closing arguments. Sometimes you have to make something for the record, and you could just say, for the record, Judge, objection, and then the judge will rule quickly if there's something. Sometimes there will have to be an objection, and you could ask to approach. Now at this point, the jury wants to deliberate. They want to hear the case, or hear what the other jurors think about the case. Some of you do criminal law. They have not deliberated, or hopefully have not pre-deliberated.
We just lost power here.
Oh, no.
So they've not pre-deliberated, hopefully. There's emergency backup.
I can still hear you.
Okay, good. So they're ready. They're ready to deliberate on the case, and you can show empathy, and you can say, "I know you're ready to talk about this case, but here are the 3 things I want you to think about," and also anticipate what questions they might have during deliberation. And one of the questions we always get, and I've never seen a lawyer say this, but I'd love it, is the juries always ask if they can have a transcript during deliberation, or they'll ask for more evidence. And even though there's an instruction that says you've heard all the evidence, or you should consider only the evidence in the exhibits, you can say you're going to have to rely on your memory. Was Mr. Smith telling the truth? You be the judge of that. You've received this mountain of documents. It's up to you now to form an opinion and share it with your fellow jurors. So you can have a little empathy with the jury that they're ready to deliberate and rule on the case that they've now heard for a week or maybe more.
One thing that I would suggest is don't let the other side drive your closing. There are times where, let's say it's whether it's contract, personal injury, it doesn't matter. Plaintiff gets up, they're making their closing argument. And I see defense counsel writing what seems to be dozens of notes, and then defense counsel gets up and they make their closing, and the plaintiff's attorneys writing dozens of notes for their rebuttal. You are not required to respond to everything that the other side said. You shouldn't let what they've done necessarily drive what you do in your closing. You've decided long before the closing argument, there are a certain number of points that you intend to make. Still make them. You can certainly weave that in and or respond to the things that the other attorney said that you think might be the most damaging to your case, but you can't let that other side drive what you do for your closing, because you're either trying to prove, defend, or come up with your own proof of your own claims or affirmative defenses, and you should be focusing on what you think the evidence was they should be focusing on. Because I've heard cases where, they sort of get sideways on some issue that I'm pretty sure the jury didn't care about, or I didn't certainly, and the jury might find it just to have been a red herring. But if you're spending your time responding to that, not using your time on the significance of whatever it is you were trying to prove, you might do yourself and your client a disservice. So I suggest you certainly can make notes. I'm not saying don't, but don't let that drive what happens to your particular closing. All right, we're going to move on to jury instructions. And for whatever reason, I have found, and I think my colleagues agree, that jury instructions in civil cases always seem to be much more complicated and difficult to put together than in criminal cases. But I don't think it necessarily has to be as complicated, at least as I've seen. So I really do spend time with opposing counsel talking about jury instructions, because if I get 35 instructions from plaintiff and another 25 from defendant, of which 10 of them, the only difference is a word or just they're the same, that's just frustrating. I don't want to see that. You guys should be able to talk enough to say, judge, of the, let's say 35 instructions, 25 of them we've stipulated to. Here they are. And here's 10 the plaintiff thinks we should be giving, and then here's some the defense thinks we should be giving that are somehow either a different Colorado jury instruction or based on something else. And as I note, use as few instructions as possible As you know, we have to read them to the jury. And the jury, as Judge Hartman talked about earlier on closing, they're ready to deliberate. We're giving them the law because that's our job. And they take it very seriously, but they don't really want to sit and listen to us read for 45 minutes. They really think you should use the pattern instructions as much as you can. And, you know, if you cite some Northwest or Southeast reported case, it's not likely that a Boulder District judge is going to go, oh, yeah, that's exactly what we should be given. It's not likely at all. And then the 2:1 instruction, again, always seems to, not always, often seems to baffle parties. But I really think you can put together a instruction that talks about what the case is about without being argumentative, being fairly neutral, and submit it, because I'll use that in jury selection too. I'll read a 2:1 instruction to the jury to let them know what the case is about. So that's something that unfortunately I've had to create more times than I thought was necessary, because I thought the attorneys, if they just really actively conferred, could probably do a better job than I can, because you guys know your case much better than the court ever will. Judge Langer?
You know, if you don't mind, why don't you go through all 3 jury instruction slides, and then Judge Hartman and I can jump in and comment on it, rather than doing it one slide at a time.
Okay.
Oh, and then folks, we'll make sure these slides are published. Kyle's going to take care of that.
So I talk about when you file these with the court, it helps if you file one set with the citations and one without. Because ultimately we have to finalize these, and usually by saying we, I really mean the law clerk who's assigned as the bailiff. They do the heavy lifting. And it's a lot easier if they're editing or having to print them out, if we have an unsighted one, but also have a cited one so we can easily go to the jury instructions to refer if there's some disagreement about language. And as I noted earlier, you know, really talk. And there's certain instructions that are given in every single case. These should be pretty standard, and counsel usually could probably agree on those. But it will help the judge to decide how much time we'll need for an instruction conference and when we take it. And as usual, even though I've noticed at least one typo in this PowerPoint presentation, check for typos and grammatical errors, even if it is copied directly from the CJI, because, you know, I always take the blame when I'm reading it. I go, gosh, I'm really sorry, folks, I messed up. But inside I'm thinking, why didn't the lawyer catch this ahead of time? Because it would have been easier. But I take the blame in front of the jury that it's on me. Just check with that. That really helps. And then I have another one here about jury instructions is a hot appellate issue. And you really don't want a case reversed and remanded based upon the giving or the failing to give a particular jury instruction. So these are important, and they are something you should, again, as I said earlier, start on early in the case and really know that you have your instructions down. And as I indicated before, you know, same thing, unless there's a case that says give this jury instruction even though there's no CJI on it, and there are a couple cases that say that, believe it or not, but if not, it's not likely the judge is going to allow too many non-pattern, because we don't want to see the reversal and having to try the case again. And then I don't know, Judge Langer and Judge Hartman can comment, but usually, you know, I'll have my conference for instructions early enough in the trial so that I'm not keeping my jury waiting again. You know, if I have to copy, let's say 35 instructions 9 times, let's say I've got 7, really 10 times. Let's say I have 7 jurors, 6 plus an alternate. Each side gets a copy, my law clerk gets a copy. That's 10 copies, 350 pages. Let's say if they're 1 page each, that might be more. Our copiers aren't that fast. And I don't want to break a case at 10 a.m. or 2 p.m., send a jury out for an hour or an hour and a half while I'm copying instructions before we do closing arguments, reading of the instructions and closing arguments. So I'll say, let's say it's a 4-day trial. On Wednesday, I may say, you guys, we're going to stay after the jury leaves as long as it takes to get these instructions done. And that's the way I do it. My colleagues can say how they do it. And just keep that in mind, because it really helps if more are agreed to, so the instruction conference is much shorter. Judge Langer?
All right, so typically during trial management conferences, I'll have a discussion about jury instructions. I'll set a deadline because I want the jury instructions in advance of trial so I can take a look at them. I'll talk about a 2:1 instruction, as Judge Butler says. We typically use those during our portion of voir dire to preview the case to the jury. And I agree that it's important to use pattern instructions as much as possible. We feel very comfortable with a pattern instruction. It starts to make us a little more nervous when someone's asking us to use some language out of a case to craft an instruction that perhaps has never even been given before or hasn't been given much. I always ask the parties to file a packet of stipulated instructions. And I typically expect, because as Judge Butler says, a lot of these instructions are given in every trial, that the majority of instructions should be stipulated. It's only the unstipulated instructions that I like with and without citations, because those are the ones that we're going to be talking about. I too will try to have a jury instruction conference maybe about 3/4 of the way through a trial. I can start to get a sense of, if the trial's set for 5 days, it's likely we're going to be doing closing instructions on the afternoon of the 4th or the morning of the 5th. And so I try to time the jury instruction conference so that we can finalize jury instructions and make the copies during a break, either over a lunch hour or at the end of the day, whatever it might be, because it takes an incredible amount of time. For some law of physics that I never learned in school, anytime you're copying jury instructions, the copier runs out of paper. It just is inevitable. Or the copier breaks or jams or something. So one of the things I hate the most in trial is having a jury sitting in the jury room while we're trying to make the copies of the jury instructions. So I always try to time it, and I appreciate it if the lawyers sort of, work with me on that to do the jury instruction conference and make the copies at some time that's the jury isn't going to be present anyway. I think that's about all I have.
Thank you, Judge Hartman.
All right. So obviously this is an important yet tedious part of the whole process. There was a case with, I think it was Judge Babcock or Nottingham, where he just walked out and said, "Counsel, here are the jury instructions. File any objections." I have yet to have the guts to do that. I think Judge Mulvihill may have done something close to that at one point, but maybe if I was a federal judge, I would have a little more confidence to do that. But it dovetails into the CGI instructions. In civil cases, there are probably too many instructions, not too few. There will be a pattern instruction for your fact pattern. I'm sure you've all read that very thick book. It's the wisdom of decades, much smarter than me, probably matching the wisdom of these judges, that have written those instructions. A judge is probably not going to deviate from those instructions too much. You'll be able to find the pattern instruction that fits your case. In fact, as Judge Butler mentioned, many of them are duplicative. So try to avoid that, because the jury doesn't understand this process. They don't understand why I have to read to them like a 6-year-old for 45 minutes. They're ready to have this case, and they think it's ready because its closing arguments are going to come, and you're reading and you're reading. And some of the carrying instructions for special verdict forms, they'll understand this. And you read the verdict forms. less is more, and stick with the model instructions. Now, there are some exceptions, and don't be shy. And sometimes you will have to make a record, either because you have a you're trying to make some policy with your firm or for your client, or you feel it's important. But understand that it's probably not going to be added to the jury instruction packet. It's a big area of appellate court reversal. It's very easy for the appellate court to focus on jury instructions rather than going through thousands and thousands of transcript pages. The copying takes an inordinate amount of time, so just be ready and understand that. One thing I'll get into, which isn't on this PowerPoint but has to do with the instructions, is after the instructions and closings, the judge will dismiss the alternate if there hasn't been some loss of a jury member, if there is an alternate. In civil trials, what I do is I randomly pick the alternate, and the appellate courts have said that that's an okay process. And I will ask the lawyers in advance if they want to have all 7 or even 8 for perhaps a 2-week trial serve. And the reason I do the random selection is it's sort of a game of Russian roulette. You may lose your favorite juror, or you may lose your least favorite juror. And with deliberation, psychology, and cascading effects and all those behavioral things, you may not want to lose Mr. Smith. And you may feel that you'll let all 7 deliberate. And I find that the jurors are a little happier when all 7 can deliberate, or all 8, because they've been together for now a week or 2, and they all are invested in this case, and they don't want to be dismissed. I only do that if both sides agree. I don't say who didn't agree. The jurors don't understand this, so they just hear that Mr. Smith is the alternate and Mr. Smith is dismissed. But that's a little footnote to these slides with jury instructions, and that would happen after closings. I won't drone on about that. In criminal, obviously, you can't do that. Only 12 and only 12, or 6 and only 6. So in criminal, I use a different process. Back to you guys.
I'm going to throw one more thing out if I can.
Go on.
One of the things I've noticed over time is that questions that come from the jury during deliberations are almost inevitably asking for clarification of jury instructions. And I just think that there's really nothing we can do about that. We can't clarify jury instructions, but I just think it's something that attorneys should keep in mind when you're asking for certain jury instructions. Is juries, that's their biggest frustration in serving on juries, is having to deal with jury instructions.
I'll add just a couple of points. I do it a little different in terms of the alternate. Ahead of the trial, I pick a chair in the jury box, and I say whoever's sitting in that chair at the end of jury selection is our alternate. And if no one's in that chair, it's the person in the next higher chair who's sitting. And I do that because as a lawyer, I kind of wanted to know who the alternate was. And I think most lawyers do. But remember, in civil cases, the jury can discuss the case from the very beginning. Unlike criminal cases where they can't talk about the case until they deliberate. Whereas in civil cases, they can. And I kind of try to encourage the lawyers to allow all of the jurors, if there's 7 at the end of the trial, to deliberate, because you don't know what they have been providing. You know, they may be someone some jurors are looking towards, or they may have some different insights. And if all of a sudden you send them home, that could be damaging to your case. It could be helpful. You don't know. But what you know is they've been chatting among themselves throughout the entire trial. And I think it is disruptive, as Judge Hartman mentioned, to the jury if all of a sudden one of their members their little jury family is sent away. So keep that in mind when you're trying to decide whether to object or concede to having the alternate deliberate in a civil case.